distinguished guests, ladies and gentlemen, Emmanuel Gaillard was without doubt a brilliant advocate. He was an exceptional technical lawyer who had mastered both civil law and common law, even English law, despite his frequent claims to be utterly mystified by it. But beyond his technical expertise, he was an extraordinary strategist and a master in the art of case presentation in international arbitration. His was a flamboyant style. He fought hard at every step of the arbitral process. He dominated hearings with the sheer force of his personality, and he dominated witnesses and experts in cross-examination. I recall him once confiding in me about what he said was his standard procedure in approaching any new case and preparing a submission. And that had two steps to it. The first step was that he took out a piece of paper and he wrote on it, "This is an outrage." The second step was he opened the file and started reading about what the case was about. In the hands of a master, this was a dramatic style that was incredibly effective because it was always carefully judged and measured, and it was all done with a wry smile and a twinkle in his eye. But there are few such masters in the field of international arbitration, few who are sufficiently skilled to deploy a flamboyant and dramatic style without the danger of disaffection of the arbitral tribunal and the other parties, and inflammation and exacerbation of the dispute. And in truth, the practice of international arbitration is increasingly exposed to both. The conduct of counsel in our field is too often characterized by excessive aggression, abusive strategy, and a lack of ethics. And if this is left unchecked, it may threaten arbitration's continued position as the principal universally trusted mechanism for the resolution of international disputes. This is not a lecture about the extreme cases of fraud by counsel, of concealing documents, of false testimony. This is a lecture about a much broader spectrum of counsel conduct and a much more insidious phenomenon. Let's recall one of the triumphs of modern international arbitration to which Emmanuel himself materially contributed, and that is the evolution of a common procedural model. Globally, the prevailing model is a mixture of common law and civil law, but it's dominated actually by an Anglo-US adversarial model as opposed to the inquisitorial model. That is what is the dominant strain now internationally. And that places the tribunal in the position of a neutral umpire awaiting education by the parties. The parties are assembled in interest groups, pitched in battle against each other in front of the tribunal. Tribunal is not expected to descend into the fray before them, but rather to stand back and umpire the combat and then judge the result. Now, in participating in this process or this combat, counsel is in the position of combatant or combatant, depending on which side of the Atlantic you live. The counsel's role is to find a way, firstly, to advance its own case, but importantly, to defeat that of the opponent. And in defeating the opponent's case, the process has become vulnerable to excess and to breakdowns. This is best explained, as I say, not by the extreme cases, not by the cases that we have focused on so far today of clear, fraudulent, dishonest conduct. It's actually explained by highlighting what is a progressive degeneration. It's a spectrum of conduct that has become more apparent over the years. And with you, I'm going to travel along that spectrum. It starts from one end with conduct that actually might seem innocuous, anodyne, and harmless. And that is the use of what's called intensifier. An intensifier is an adverb or adjective which is intended to lend force or emphasis to the meaning of another word or a phrase. So the common examples in legal writing of intensifiers are the words clearly, merely, very, highly, undoubtedly. These are used for largely therapeutic purposes. They are to reassure the writer rather than the reader. They are actually ornamental and not substantive. In fact, they tend to hamper rather than enhance the prose. They lull legal drafters into a false sense that they have actually given a substantive persuasive reason for a legal conclusion. You can lull yourself into that by using the word clearly. In fact, it adds nothing at all. If it's clear, it's not going to get more clear by using the word clearly. And if it's unclear, it's certainly not going to be clear by calling it clear. At best, it's a distraction. It's drafting clutter. Please compare the following phrases. Firstly, it is obvious, therefore, that the respondent's case is clearly unfounded. How different is that in meaning to the phrase, the respondent's case is unfounded? So actually what you're doing often with the intensifier is you are signaling a weak argument, because the person who is reading it will reflexively think the opposite. Stephen King, the famous novelist, in his work on writing, wrote, "The road to hell is paved with adverbs." In fact, amazingly, there is an empirical study done by two academics, I won't name them, Lance Long and William Christensen, who obviously haven't got enough in their lives. They did a study of 800 federal and state appellate briefs in the United States to work out if there's a correlation between the use of intensifiers and the end result. I don't know who funded it. Anyway, the result is there is indeed a correlation, that the more use of intensifiers leads to less chances of success. That has got no plausible causal analysis attached to it, but it's a rather interesting result. What was more interesting to me, however, was another facet that came out from this work, and that is looking at dissenting opinions amongst judges in American cases. And it was found that when you have a dissent and you have a minority-majority judgment, you are much more likely to come across the word clearly. As things become less clear, the word clearly is resorted to more. Now, that's the beginning of the spectrum. We're not in deep trouble at the moment. There's no particular difficulty, but it's the beginning of a progressive degeneration. Here's the next step. The next step, which is only a small step, is the accusation. Increasingly, the nature of the intensifier has changed. We have shifted from clearly, merely, very, highly, undoubtedly, to the harder, more pointed, brazenly, utterly, woefully, blatantly, to the accusatory, deliberately, knowingly, intentionally. So the phrase, the respondent's case is unfounded, it travelled to, it is obvious, therefore, that the respondent's case is clearly unfounded. But now it is normally morphed into the following. It is obvious, therefore, that the respondent has deliberately advanced a clearly unfounded case. That might seem like a small step, but it's not. That is crossing, even though it's commonplace, it's crossing a major threshold. And that's a threshold which we now have to pause and consider. Because actually if you step back and think, what you're doing once you change your intensifier to an accusation is you are levelling a very serious attack against a fellow professional. What you're actually saying is that your opposing counsel is acting with dishonesty. They are not just advancing an incorrect case, they are doing it intentionally, deliberately, That is a very serious allegation against a fellow professional. The ease with which we make that accusation doesn't take away its severity. These are intensifiers that are now increasingly peppered throughout briefs and oral submissions. And they lead on to more direct accusations, such as that the claimant's case is disingenuous, it's an abuse, it's in bad faith, that the claimant's submission is deliberately misleading. You are saying, if you say that opposing counsel has acted in such a way that in most systems they could be reported to their regulator. They are actually being dishonest. Counsel, in my experience, especially in my cases, opposing counsel are very often wrong. But how often are they actually dishonest? How often is a fellow professional deliberately, knowingly misleading? It gets worse. We're now traveling in more dangerous territory in our progressive degeneration, because it's only then a very small step to the legal representative's poisoned letter. Exchanges between counsel are now commonplace. As increasingly as one approaches a hearing, there will be a flurry of correspondence. That correspondence will be poisonous. It will set up a satellite, separate, parallel battlefront. The letters will accuse counsel of all sorts of objections, possible objections we raised, whether it's demanding information that hasn't been provided, documents that haven't been provided, or criticizing an approach, and often in a precursor to the letters being then shown to the tribunal. And increasingly, and notably, the tone is dreadful. The tone will be aggressive, it will be condescending, and it will be replete with accusations and insults. And indeed, this is now seen as a key element of strategy in the adversarial process. With law firms, none in this room, because I checked, law firms with dedicated parts of their team just on letter writing. And the strategy is one of bullying, of distraction, of pressure, of draining resources. But it gets worse. Because as we travel along this progressive degeneration, the next step we come to is the ad hominem attack. The ad hominem attack is most acute actually in oral submissions. Now, just recall the traditional form of this adversarial model that we are now using internationally. Where did it come from? In its Anglo-US roots. It came from practice in court in an old bygone period where the bar was small, where everybody knew each other, where there was self-regulation because of familiarity. And that small geographical scope gave rise to a system of court etiquette, of courtesy, of civility and respect for the dignity of others. And indeed, that was despite the cut and thrust of the adversarial system, because that self-regulation was possible in a small geographically defined group of professionals. In the words of the Chief Justice of Singapore, Chief Justice Menon, in the introduction to a book on counsel conduct, he says, "A person's fitness to join the ranks of the legal profession is first and foremost about character, and then competence." And the manifestation of that traditional system actually gives rise to court language that you still hear in international arbitration. But the court language has a different root. So, for example, the expression "with respect." We all know what that means. With respect means with no respect. But we use it because it's civil and because it's a way of not demeaning anybody and maintaining courtesy. And if you want to be incredibly rude and say, in fact, that your opponent is an idiot, you would say, "with great respect." Not quite sure what that does. Anyway, we'll see. Then, of course, in the system, in its root, instead of what you would have in the Hollywood blockbusters of the attorney standing up and slamming the desk and saying, "Objection," in the English court, the way that we've dealt with that traditionally is with a deliberate and very noisy clearing of the throat, where you go, which is your way of saying objection.
And then, of course, we have my learned friend. And my learned friend, which you do here in common parlance, has a particular root. The root is to respect the status of your opponent as being learned, even if manifestly they're not. They're learned friend because that's anonymous. And that takes away their individual personality from the debate. And it's a courtesy and it's respect. My own mentor, Johnny Vida, close friend of Emmanuel Gaillard, had a very strong rule when I was his junior. His rule was he would never, ever, at any point in any case, mention his opponent's name. Because he said the name is irrelevant. The person is irrelevant. The only relevant thing is the argument. So you are playing the argument, the man, not the ball, as he would say in sport. There is a subtext to that, which is Johnny could never remember his opponent's name. But that's not relevant for now. Now, with this degeneration, we're now faced in a different situation, because we're not in a small, geographically confined area of professionals. We are, happily, in a global system. That global system is large. It's not so select in the way that a distinct national system is. And that means because the pool is larger, accountability is smaller, because familiarity is less. The key inhibitor of people being rude and lacking in courtesy is the expectation that you know somebody or they will know somebody or you will come across them again. And in international practice, that inhibitor has been manifestly weakened. And therefore now the attacks are ad hominem. The attacks are not just about the argument. They're focused on the person, their characteristics, their intelligence, their reliability, their competence and their integrity. And all of that gets bound up now with other aspects of bad behavior in hearings that you wouldn't have in a traditional geographically confined system. That bad behavior can be submission by facial expression, submission by yawning, snorting, interrupting. The standards are manifestly degenerating. Now, these aspects of counsel conduct have to be put against a wider context of ethical pressures that are now undermining our adversarial system. And there isn't time to identify all of them. A lot of them have been spoken about earlier today. But let me just mention some of them, because this is the context that is all collectively putting stress on our system. Our system depends upon witnesses, like it or not. There are many reasons not to like it. But the witness component is under pressure. And that's at every stage. For example, the idea of witnesses used to be that you would find the person who could give the best evidence. That's not what we do. You find the person who will be most resilient to cross-examination and most attractive to the tribunal. If your best evidence is coming from somebody who can't string a sentence together and will be demolished in cross-examination, you don't put them forward. So the system touches on ethical questions as to what evidence are you actually bringing forward anyway to the tribunal. And then, of course, we have the preparation and coaching and rehearsal of witnesses. And then we have the witness statement itself. And of course, and I know this sounds ridiculous, unbelievable, there was a time when a witness statement was the statement of a witness. But obviously, we're way beyond that now. It's a submission. It's in the same font as the main memorials, and it's in perfect English. And then, of course, there are problems of false testimony. So there are pressures, and a lot of them are ethical pressures on the witness component. The same can be said for the expert component. How is it possible that every single argument, however appalling, will have an expert attached to it, confirming it? There'll always be an expert in our system, perhaps outside Brazil, of party-appointed experts. And that's because we have this extraordinary phenomena of expert experts. These are people who rejoice in the fact that they've testified many times before a tribunal. When I'm sitting as an arbitrator, this is confidential. When I sit as an arbitrator, I am most impressed by an expert who's never testified before, least impressed by an expert who says, I've testified in 100 cases. And then, of course, we have challenges to arbitrators, we have due process threats, we have guerrilla tactics, we have documents being withheld, we have all the phenomena we've spoken about already together today, and we have the extreme examples that we've had in the past of guerrilla conduct, such as kidnapping your arbitrator. And we all know the Himperna case. Now, let's stand back. If you put all of that together, you can see the progressive degeneration. The end result of our adversarial process, one must ask, as a matter of analysis, how different is it to trial by combat? How different is it? Because actually, rather like the ancient system of trial by combat, where you would fight in order to work out who is innocent and who is correct, we are also in a system where we position ourselves to participate in a prescribed fight in front of an umpire. And we do so by making sure that we will have the strongest team members available, including strongest witnesses. And we do so with strategy focused on overpowering our opponent. There's quite a lot to be said for trial by combat. There's certainly finality and efficiency. And indeed, in the 13th century, the precursor to the IBA was the German code called the Sachsenspiegel, which set out rules for trial by combat, believe it or not. But analytically, is that really where we want to be? Now, why does all of this matter? It matters looking at ethics in a broader way. It matters for at least 3 key points. Firstly, bad behavior of the sort that I have described, along that spectrum, from the mild to the serious, all of it exacerbates and complicates the arbitral process. It renders it harder to resolve. It becomes more tense. It becomes more strenuously fought. And that means less flexibility, less prospect for collaboration and cooperation, and it increases satellite parallel litigation or indeed arbitral process. All of that means increased delays, increased costs, reduced chances of settlement. Secondly, it impacts adversely on the tribunal's task itself, directly, because for the tribunal, it means the dispute is harder to manage, and then it's harder to resolve. There's less common ground, there's less focus, there's more distraction. Counsel become less reliable. You can't even trust them. So then what do you look at? How do you get educated? And the dispute becomes more polarized. Now, in that setting, the tribunal becomes less good itself at resolving the dispute because it gets confused. It's less focused itself. It's not been assisted. And a tribunal that's unassisted is more vulnerable to shortcuts and superficiality and picking on the wrong thing. And I'd like to tell you some names at this point, but I won't. That danger of polarization becomes even more acute in investor-state arbitration, where the stakes are higher, where tribunals are mandated to resolve sensitive, nuanced questions of policy. Questions of policy that are grey, not black and white, like climate change, like health policy, like nuclear power. But they do so now with an adversarial process that provides them with utterly polarized positions, where the middle ground where policy normally exists is empty, because everybody has been so inflamed and therefore is fighting each other from extremes. And thirdly, this has an overall impact on trust and legitimacy of the arbitral process itself. The whole system, if it's going to be delayed, if it's going to be costly, if it's going to be aggressive, if it's going to be unethical, the whole system actually becomes illegitimate. It falls into disrepute. People no longer have confidence in it. It's not flexible anymore. It's not efficient. It's not cheap. And actually what happens is there are greater post-arbitration scars. The impact of an arbitration is actually lasting, enduring ill will. What are the solutions? There are a number of solutions that we have canvassed for many years now, and a lot of them have been canvassed today. They are frequently discussed and they've been tested to varying degrees over the years. Let me just chart them very quickly. The solutions come in terms of the tribunal's power, first of all, to sanction bad behavior. And that is a power that comes from a number of sources. So we know, and I'm not going to spend time giving you articles and details and quoting, but we know there are codes out there are rules that apply that contain express powers. So powers that will enable a tribunal within the scope of its jurisdiction to actually sanction bad behavior because it's considered sufficiently close to resolving the merits or involved with that mandate. It's part of the task. And one can see it in national rules, rules of institutions. One can see it recorded in cases. There's then, secondly, to my mind, the more interesting topic of inherent power. And there's a lot of learning on what are the inherent powers of arbitrators. And we've discussed some of this today. And if one were to look at one of my favorite cases, which is the Iran-US Claims Tribunal decision of E-Systems, and look at Howard Holtzman's separate opinion, which gave rise to the whole debate and recognition of the power of an arbitrator to issue an anti-suit injunction, essentially, to stop a party from defeating the arbitration by going before a national court. If you look at his reasoning in that case, you can, and by the way, that was something which Emmanuel and I debated actually in Montreal, in a, I think it was an ICA debate on the powers of arbitrators. You can see from that the same logic will give you an answer on inherent powers. And the answer is, if the tribunal's mandate is to resolve the dispute, then the penumbra of that mandate is to make sure that they're able to resolve the dispute. And anything that prevents that ability, which undermines the integrity of the process, is within their power, so that they can resolve the dispute. That means sanctioning people, stopping them from behaving badly. Just very quickly, in answer to earlier issues, there's a line that naturally appears there, being, if you don't need to do it in order to resolve the dispute, then maybe it's not your job. Do you need to report to a regulator? It's not really your job. But do you need to stop the conduct so that you can resolve the dispute? That's part of your job. So there is a natural demarcation of what tribunals can and can't or should or shouldn't do. So that's a whole debate on inherent powers. And beyond that, there's also, of course, the duty to arbitrate in good faith, which is a duty that's increasingly recognized. Meg Kinnear has given recently a brilliant speech about procedural good faith and has charted out, which I was going to steal without crediting her, but I'm not going to now. No, she's it's not true. Can we delete that? She has charted out the cases in the investor state context which have now recognized a duty of good faith in terms of procedure. And that is something which really has an application well beyond just investor state arbitration. And then, of course, there is the issue of ethical codes. And we all know that there have been many of them tried over the years and with varying success. Now, I go through that at speed because we have debated that for years. This is not new. Not much in our field is new, to be honest. We have for decades, actually, been talking about ethics. We've been talking about these possible solutions. The tools have been available to tribunals to sanction bad behavior for a long time. The question is, why have they not been applied? And there is actually one specific reason, to my mind, that has prevented a proper application and use of what is already available. And that is the pervading, highly contagious condition of due process paranoia. It is the fear of arbitrators, the lack of the courage that Emmanuel had. It is the concern that they might be challenged. That if they do something which is out of the ordinary, which is proactive, then they may be challenged, or the award may be set aside, or the award's recognition and enforcement may be defeated, and you don't know where that will be around the world, and therefore you play it safe. That's a paranoia, because it exists quite apart from the reality of the chances that there really would be a challenge, or the chances that that challenge would actually be successful. Of course, what is common now in terms of counsel behavior is the due process threat. And that happens all the time. So you actually actively scare your tribunal out of using the available tools by saying, I put down a marker now that I'm being denied due process. And that casts a shadow over the rest of the proceeding. So where do we go from here? And this now is the real focus. What do we do? Do we carry on talking about the same tools? Do we have a solution for due process paranoia? My suggestion is as follows. The key solution, which is one to enhance all other approaches, to enhance the efficacy of ethical rules, to give courage to tribunals to step in, is for us all to recognize that the problem we are facing affects the international rule of law. If that is a perspective that we can actually understand, and if it's a perspective that can be embraced by all of us, counsel and arbitrators, then it puts the entire situation in a different light. And it gives courage, should give courage to everyone. So let me now say a little bit about the international rule of law. I'm going to start with the following. There is a well-known concept called declinism. Declinism. This is a belief that the world is worse than it ever has been before. It is a cyclical human perception whereby each generation views its own time as uniquely troubled and idealizing the past. Of course, I should say it has also been observed that the end of the world has been coming since the beginning of the world. But in any event, if we were now to look at the state of our world today, from the perspective of international law and international legal order, there is little cause for celebration. There is much reason to believe that today we are witnessing a very sharp decline. With every passing day, we are bombarded with breaking news headlines of international conflict, increasing worldwide division and polarization, the redefinition and assertion of national interest, the full frontal attack on international law, on international institutions, and on what we had all assumed was a post-World War II settled world legal order. But it is not all doom and gloom. The resultant sense of instability that we may all feel now brings into sharp focus a very critical point. And it's a critical point that actually we should celebrate. And that's as follows. The fact is that we, as a community of specialists in international dispute resolution, have over the past 60 or so years actually managed to put in place a highly stable and effective transnational legal structure for the resolution of disputes, something of which Emmanuel was an architect. It started way earlier, of course, with the 1958 New York Convention, which is our constitution. It traveled through the 1976 UNCITRAL rules, the 1985 model law, which gave rise to the gold standard, both of law and rules, which were then copied all over the world, north, south, east, west. And we have a wealth of other soft law and instruments comprising now what Emmanuel trumpeted as a transnational system. Now, that is a transnational system so far that is not caught by division and polarization. Somehow, it's not subject to the pressures and vagaries of national interest. On the contrary, it continues to grow. It continues to have importance. And it's a continued priority for countries worldwide in terms of advancing their commercial interests. And because of that common interest and commercial priority, it seems so far, touch wood, to be insulated, largely insulated from the turmoil and uncertainty of interstate politics and national self-interest that we read about every day. That is an incredible achievement. It's an achievement that we have to not only celebrate, but we have to value. And it really comprises a core element now of the international rule of law. Now, when you talk about rule of law, of course, we have procedural rule of law. That has components such as access to justice, right to fair procedure, consistency, predictability, transparency, equality before the law, and formal legality of state action. You also have substantive rule of law in terms of actual substantive standards. But here's this. There are critical interrelationships between our transnational system of dispute resolution and international rule of law. Critical connecting points. And here are just 4 of them. I could give you 8, but there would be a collective drop in morale. So here are 4. Firstly, the process of dispute resolution itself is actually now manifestly critical to international access to justice. Access to justice is part of international rule of law, but just think how much of the world's international disputes access justice through international arbitration. That is a major component of international rule of law, as is the right to fair procedure, consistency, predictability, transparency, equality before the law. Those are the list I gave you of procedural indicia of rule of law, but actually they're in our hands, because so much of that actually depends upon our transnational system of international arbitration and not on national court. The sheer number of disputes that we deal with every year. That's the first one. Second one, recourse to our transnational dispute resolution mechanism acts as an external check or discipline on domestic rule of law. Because what we've created is a system that operates outside of one national sovereign territory. And that allows for an outside view of an internal political system. It's actually immune, not completely, but it can be immune or at least largely protected from local domestic politics. It actually can look at domestic institutions, it can look at domestic politics and influences externally, and it can impose externally standards. And those standards give rise to good governance, which is part of rule of law. And they give rise to increases or differences in improvements in local domestic values. That is throughout our system. It's obviously pointed and acute in investor-state arbitration, because investor-state arbitration is partly designed for this, to actually discipline states externally. But even beyond investor-state, that is a very important mechanism. Point number 3, if you view it historically, the system of international dispute resolution has been critical in averting conflict and actually maintaining peace and international stability and order. I have to here quote from Emmanuel's good friend, Johnny Vida. Johnny Vida said famously in his 2001 Goff lecture, he said as follows: in 1937, the ICC Congress met in Berlin, where its opening session was attended by the German Chancellor, Hitler, and his colleagues, Goering and Goebbels. This is true. Imagine Hitler at an ICC conference. It's true, 1937. And even then, the ICC's new president, the American Thomas J. Watson of IBM, felt able to proclaim in the keynote of the conference, world peace through world trade. Thomas Watson was right, but not as right as he would be 50 years later. The great cause today is the same, but still greater. Without world trade, there can be no world peace. And international arbitration is the oil which lubricates the machinery of world trade. That remains true. Fourthly, within this system of international rule of law, one must consider the role of counsel. Counsel, who Johnny Vida in his speech referred to as the mechanics, oiling world trade. Counsel have an integral structural role in the rule of law because they have a structural role in our transnational system. That is a special status of near constitutional responsibility in our system because their own conduct bears directly on the quality, the effectiveness, the legitimacy, and the fairness of the process. Because if counsel misbehave, the system breaks down. It is dependent on them. In fact, if you look historically, the clearest demonstration of this fundamental tenet that lawyers, as well as judges, are uniquely responsible, individually and collectively, for protecting the rule of law. So the clearest demonstration of that are the historical instances where they have catastrophically failed to do so. And actually, interestingly, one of the best/worst examples of lawyers catastrophically failing to uphold the rule of law was actually their activity during the rise of Germany's Third Reich. There is an incredible article that was written in 2020 by Cynthia Fountaine, focusing on complicity in the perversion of justice, looking at the role of lawyers in Germany from the 1920s through to 1939 to 1945. And it's a study of lawyers who were not Nazi supporters, but they had their own self-interest, their own professional preoccupations. And in the course of those preoccupations, they failed to stand up for what was actually happening. And actually what happened was the perversion of law. It wasn't the abolition of law. It was the promulgation of Nazi laws, which led to a chaotic system, which led to the undermining of the rule of law. But the gatekeepers, the mechanics, were absent. Those were the lawyers who actually could have resisted it, but they didn't. Now that's an extreme, emotive, historical example. But what it proves is actually the constitutional role within our system that lawyers have. So with that wider significance of the interrelationship between our transnational system and the international rule of law, and the role of counsel within that system, and the critical importance that we maintain, that we preserve and we protect what is actually an incredibly valuable system that so far is continuing. With that context, we must recognize the following. We have in our hands the opportunity and potential to safeguard and develop the transnational system, and thereby safeguard and develop the international rule of law. But we also have in our hands the ability to undermine it. And that is the ability which manifests in bad behavior, which manifests in a duty upon us all to stand up to that behavior. That is for our collective benefit, but it's much, much wider, much broader than that. We cannot let the international rule of law fail, and if a critical component of it is our system, then we are duty-bound to protect our system. That imposes itself high standards on counsel, high standards on arbitrators to use the tools that are available to them, knowing the danger if they don't. And it leads to this. It leads to a big picture vision of counsel's role and mandate. It is a role and mandate that goes way beyond the forces that bear on counsel from each individual case and each individual client. Their role is bigger than the individual case. It's bigger than winning the instant dispute. It is a role where integral to it is the maintenance of trust and confidence in a system. And that is a vision so often lost in the fervour of counsel to win and win at all costs. And I'm afraid it is increasingly a vision lost in a world dominated by LinkedIn vanity and self-congratulation. We are now borrowing from Emmanuel's brilliant sociological study. We are lost in a sea of directories and brochures, wholly subjective listings comparing professionals according to utterly vague and unscientific metrics, what Emmanuel termed merchants of recognition in his Freshfields lecture. Dedicated departments in law firms, none here, to service the directories. A system of tactical, reciprocal accreditation and recommendations. You scratch my back, I will scratch yours. Which we can applaud at what Emmanuel termed arbitration recognition tournaments, and then announce the results on LinkedIn. Please remember what Johnny Vida always used to say. He used to say, never take a professional directory seriously unless you are listed in it. And please recall Emmanuel's promise, which unfortunately he never fulfilled, which was to write a study on arbitral narcissism. All of this degrades the role of counsel. It clouds our judgment. It obscures our higher constitutional role, and it's a role that actually now has become more important and more urgent than ever before. Let me add one further controversial note to this. We also face, in our day-to-day decline, unprecedented times, especially in the United States of executive orders targeting law firms. That is a new form of attack. We take umbrage as lawyers because these are executive orders that are focused upon associating a lawyer with a client or cause. They are picking on lawyers because lawyers have run an argument that the current administration finds unacceptable. But bear in mind this, there is a quid pro quo. Because if we, as honourable members of this profession, or members of an honourable profession perhaps, if we are reacting against that, the quid pro quo is we ourselves have got to engender respect and honour. We can't expect to be able to fight interference from others on the basis that we are too close to our causes and our clients, if indeed our behaviour manifests that we are too close to our causes and our clients. And therefore, if we as a legal profession are under attack, we must look at ourselves and we must consider what is our role, what is our perspective, what is our true mandate. In conclusion, the problem of ethics and conduct in international arbitration has been with us for a long time. But as standards sharply decline, and as the value and significance of the process sharply increases, the situation is now more urgent. We have tools available. But to make them effective, it is essential that we stand back and properly conceptualize the issue. We must learn from Emmanuel and his ability to stand back and see our process in a wider context. It was his philosophy of arbitration in the legal theory of international arbitration. It was his view of the sociology of arbitration in his Gaillard Lecture that gave a bigger picture and a platform to reconceptualize. We must return to the adversarial model in its original form. We must never forget that we have in our hands an incredibly valuable system with a significance well beyond our immediate career objectives. And we must recall that there is a dangerous, slippery slope that begins from the first ill-judged adjective. Thank you very much.